accompanying friction between the executive and the judiciary is all too real, particularly when we see that the memorandum of procedure for appointment of judges to the Supreme Court and the High Courts is still pending finalization. What I think we must not forget is that the impasse over judicial appointments and thoughts about the broad debate over this issue are deeply anchored in questions of historical developments, doctrine, and comparative perspectives. Our book, ladies and gentlemen, right here, deals with crucial questions about historical developments that got us where we are insofar as judicial appointments are concerned. Our book also deals with crucial questions of constitutional law doctrines that are very crucial to the inquiry right here. We've also tried to explore comparative law that we can possibly look at to find out reforms, measures for reforms that are palatable to everybody concerned. Post 16th October 2015, I believe an important historical development has been added to the narrative on judicial appointments in India, and that is the National Judicial Appointments Commission case. Our book here uses the NJAC judgment as a springboard to discuss the doctrine, politics, and comparative perspectives with regard to judicial appointments. We thought that in the interest of being bipartisan and to also provide a holistic view of the judgment, we should have essays from lawyers representing both sides in this case. So while we have Mr. Arvind Datta dissecting the NJAC Act and pointing out its fatal flaws, we also have the former Attorney General, Mr. Mukul Rohatgi, who points out what was possibly right, hard as it may be to find the possibly right things with the NJAC Act, but he tries to find out what is possibly right with the NJAC Act and the 99th Constitutional Amendment. At the end of the day, I believe, and I'm sure most of you here would join me in this view, judicial appointments cannot solely be considered to be a question of Indian constitutional law, and it is as much an issue of the politics of the day. This is where an essay by Mr. Pratap Bhanu Mehta comes in, where he discusses the politics of judicial appointments in general and the NJAC judgment in particular. And he kind of demonstrates that how the judgment, as well as its fallout, is symptomatic of the waning trust between the executive, between the various organs of the government. Neither, well, is this an unprecedented situation, nor is it unique. We firmly thought that an inquiry into appointments in India can benefit immensely from how foreign jurisdictions go about appointing their judges. So we looked at some of our neighbors, including Sri Lanka, Nepal, and Pakistan. And we also traveled a bit further and looked at UK, Canada, and South Africa. I must take this opportunity to thank all our contributors to the book who were extremely cooperative throughout the entire editorial process. In hindsight, I do feel that the constant pestering from two over-enthusiastic editors might have been the source of constant irritation, a slight irritation, but our contributors were nothing but supportive during this entire process as we inched closer to completing this volume. As editors, Arghya and I would like to thank the Oxford University Press India, particularly Ms. Shreya Lal, Mr. Manish Kumar, Mr. Arjun Bhargav, Ms. Kanika Suri, and Mr. Shogato Ghosh for their constant support throughout. It has been an immense pleasure working with OUP on this volume, and we hope that this is the first of many academic publications to come out of the Vidhi Centre for Legal Policy with OUP India. I must take a minute to mention that Mr. Jaitley wished to be with us here this evening. However, certain serious health concerns kept him from doing so. He sends his regards and best wishes for the book as well as for the event. And on behalf of all of us present here, I would like to wish him a speedy recovery. Finally, we were extremely privileged to have the late Mr. Tehemtar Antharajina write an essay for this book. He wrote on judicial appointments during the emergency, something that he lived through. He wrote an essay for us before his unfortunate demise in March last year. It was an honor working with Mr. Antharajina on his particular essay, and it seemed only befitting to dedicate this volume to him and Mr. Anil Diwan, both of whom were stalwarts of the Indian bar, and both of whom we lost last year, unfortunately. With these opening words, I would like to welcome everybody, particularly our panelists, for a panel discussion which I hope is very exciting and enlightening. I would also like to now invite our panelists on stage for releasing our book and then to take their seats on stage. Thank you very much, ladies and gentlemen.
Thank you very much, Ritvika, for those opening remarks. My name is Sengupta. I've co-edited this volume with Ritvika, and I'm the research director of the Vidhi Centre for Legal Policy. For anyone who's followed the Supreme Court in the course of the last couple of decades, we all know that the zeitgeist of our times is of a court that is overwhelmingly credible in the public eye, enjoys a great deal of public confidence, but paradoxically seems to always remain in a state of internal disarray. And its appointments and accountability mechanisms have been questionable for a long period of time. And for the last 4 years, as everybody knows, it's been engaged in a dogged attritional war with the government on the question of judicial appointments, particularly on a memorandum of procedure. Rarely, if ever, has such a procedural document become such a bone of contention between two organs of government. But this is where we are. The late Tempton Andhyarojana, who Ritvika mentioned in possibly his last piece of writing in this volume, quoted Benjamin Cardozo in saying that the great gulfs and currents of our times do not change their course and pass our judges by. And I don't think it passes our judges by in the Supreme Court today as well. Much has been said about the kerfuffle between the executive and the judiciary, particularly in the last few days. And those have discussed particular specific issues to do with the power of the Chief Justice, the power of his brethren. And today, in this panel, we'd like to expand the scope of this discussion to certain larger questions of how did we get here with the Supreme Court, where is it that we are going, and what can we learn from other jurisdictions where questions of this nature have arisen in the past. And that's what we hope to discuss in about the hour that we have. And if time does permit, we might even take a few questions. I'm delighted to welcome today Justice Chelameswar, judge of the Supreme Court of India and one of the finest judges that the Supreme Court has seen, and Professor Paul Craig, Professor of Law at Oxford University, and my supervisor for my doctoral thesis, which sparked my particular interest in this subject. Justice Chelameswar, if I could start with you. In your foreword to this volume, I've noticed that you wrote about King Solomon and Dharmaraj, two wise and legendary dispensers of justice. I was wondering whether you think that the qualities that are required of judges are timeless, or do you think that there is something in the context that determines who is a good judge?
I think there are certain qualities which are timeless. A judge is required to be impartial. I don't think at any point of time in the human history any sane person ever believed that a person who is not impartial could be called a judge. Now, insofar as decision-making process is concerned, the processes could vary from time to time, place to place, depending upon the prevailing legal environment. That's it.
But do you think then that the appointment processes that we've had in the Supreme Court, perhaps looking back right up to 1950, not just the collegium system which is in vogue currently, is designed in order to capture those qualities? Or do you think there is something lacking which we need to think about and work on in order to ensure that we have judges perhaps not like King Solomon, but perhaps as close as possible?
My own view of the matter is the Indian Constitution is designed to secure that quality. In practice, how sincerely it was implemented is a different matter. There have been, in my view, there will always be, whatever be the system, there would always be aberrations. But essentially, I didn't find anything wrong with the design of the Constitution in this regard.
So do you think, just to probe you a little further on that, do you think the change to the collegium system in 1993 was necessary as either a legal or a political matter?
Arghya, well, this is an area where I can't comment, you know.
Right.
Especially for a few more days. Even otherwise, my views are clearly in black and white. I was in that case. So what more do I comment about it?
That's right. And well, I think that actually reminds me of a phrase that David Panic used, which is that judges are paid to do what most of us don't want to do, that is make decisions. So Paul, turning to you, one of the issues that was raised both in the NJAC judgment that Justice Chelameswar was a part of and hence cannot speak about, as well as generally during the course of debates in the public discourse in India today, is about the change in the method of judicial appointments in the United Kingdom. The move from the pat on the back by the Lord Chancellor to a system where it's a more open, transparent process with the Judicial Appointments Commission. Just so that we can demystify this, because it almost seems like gospel to say that the Constitution Reform Act is working well. What is your sense of the change that the Constitution Reform Act has undergone and about its transferability to other jurisdictions?
So thank you very much, and let me just say at the outset a broader thank you for inviting me to this very interesting debate. So just to approach it in two stages, to approach the question which will get asked in two stages. First of all, I think that one needs to reflect a little more on the status quo ante, the position which existed in the UK prior to the 2005 legislation. So yes, it was a pat on the back by the Lord Chancellor, but the pat on the back by the Lord Chancellor was preceded by pretty rigorous background checks on the people who were going to get the pat on the back. So the pat on the back was the consequence of a fairly rigorous evaluation, and the rigorous evaluation took the form of an evaluation whereby peers were asked how good this person was as an advocate, how suitable they would be as a judge, and existing judges were asked about the quality of the advocacy skills and judgment broadly conceived of the person who was being considered for a judicial appointment. So I don't think in that sense, if you judge it in consequentialist terms, I don't actually think the status quo ante worked badly, and there was certainly no sense in the UK whatsoever that the Lord Chancellor would use his or her power, though it was usually a him, for political purposes. So there was no sense whatsoever that a Conservative Lord Chancellor would use the power of appointment in order to appoint Conservative with a small or large g judges, nor was there any sense the other way round if there was a Labour Lord Chancellor. Nonetheless, there was a strong sense that it was an outdated system and that times had to change. And that, hence the reform in the 2005 legislation. Now, my sense of the 2005 legislation is that structurally in the UK, it's a good system. The composition of the appointments panel, I think, works well. The mixture therein of people who are judges or ex-judges and outsiders, as it were, I think works well. What I would say is that all systems tend to have somewhat unintended second-order consequences. And I think I don't have empirical data to base this on, but one of the impressions that I have received is that the nature of the appointment process and the application process and the interviewing process, which the UK system now entails, can be a bit daunting even for tough barristers who are going to seek appointment. And actually, I think to some extent, and again, this is only, don't, as it were, quote me, though someone probably will, but don't quote me in terms of any empirical study because I don't have one. But I think it's also the case that if you are in the High Court and going to the Court of Appeal, or in the Court of Appeal and seeking to go to the Supreme Court, you are literally putting yourself on the line in making that application. And I think that that is something, and I'm not saying that's wrong, I'm merely saying that that's something that some judges might feel difficult in doing, particularly if they've been pushed back once already.
But given that, Justice Chelameswar, since this is reflecting on what could happen in the future, can you see a day in India where people are applying for judgeship to the High Court and the Supreme Court, given the fact that perhaps it would have been as unforeseen in the UK in 2005? It was very much an honor to be called up to the bench, and it is still an honor in India today. Do you think a change of this magnitude, just to be provocative, do you think a change of this magnitude is possible?
You mean officially applying for it?
Officially.
Well, so the world is going that way. Why would Indian bar will not go that way?
So you think that this might...
Possible.
So I think this sort of brings me to something that Arun Jaitley has a volume in this essay, and he writes in this that, and I'm just going to look for the page here, where he's written a piece on the judicial collegium and the functioning of the judicial collegium. And he says in this case, and I'm quoting, "The non-consideration of the names of Justice A.P. Shah, Chief Justice of the Delhi High Court, and Justice A.K. Patnaik, Chief Justice of the Madhya Pradesh High Court by the Collegium, despite their seniority in comparison with the judges recommended, raise considerable doubt as to whether seniority is a criterion or a self-serving tool to be used at will." Do you agree? This has nothing to do with the judgment.
See, my own position in this matter is this. Some amount of maintenance of the records of the collegium would eliminate this possibility. What exactly goes on in the collegium meetings? And what is the nature of the assessment that is undertaken at the time of choosing or rejecting a particular name is required to be a little more transparent. I don't know. Of late I've been into quite a bit of controversy in this matter. But anyway, a little more doesn't help in the interest of the institution. Doesn't harm, I guess, in the interest of the institution. An assessment of the performance of a judge, High Court judge, but I'm specifically talking about elevation to the Supreme Court. That is hardly done. Generally, the assessments go by impressions. That's where the difficulty is. And once that assessment is there and the proceedings are recorded, why a particular candidate is being rejected or a particular candidate is being approved, most of these comments could perhaps be avoided. A more transparent system. Now, there can be, I'm not saying only the quality of the judgments is the only relevant consideration for choosing a person to the bench. There can be other attributes and other elements which go to the making of a good judge. That's a different assessment. I think on each one of these things, some assessment is required to be done, either by the collegium or by the state, depending on the nature of the element which is being assessed. Each one of the bodies which is involved in the process is required to place its assessment on record. That would eliminate most of these problems.
That's right. And I think that's one of the key thoughts that's coming in as far as reform of the system is concerned is transparency. The second, which we hear all the time, is about criteria. Can we think of objective criteria for appointment of judges? And just to continue the thought that I left with Justice Chelameswar, the seniority convention for the appointment of the Chief Justice of India is followed because of the fact that it's seen as objective. But everybody who's familiar with the judiciary knows that it essentially allows the subjectivity to be disguised somewhere else. That is when the person is brought to the Supreme Court. And we also have a situation where Chief Justices of India have extremely short tenures. As in, the average over the course of the last 10 years is about 11 months for each Chief Justice, which is a really short period of time to effectuate any change. Do you think, Paul, that objectivity in terms of appointment is possible? Or do you think essentially at the end of the day there is a subjective judgment that has to be made, whether this person is good or bad, suitable or unsuitable, and we have to trust the people who make it?
I think the answer to the question is that I think it's, I have a strong belief that there are objective criteria out there. I also think, and this is not a fudge of the question, I think this is a logical consequence. I think there are objective criteria, and I'll say a word or two in a moment about what I think those objective criteria are. I think there are objective criteria. I think there are also inevitably going to be, there's going to be an element of subjectivity as to whether the objective criteria are met in a particular instance or not. And I think that's inevitably so. So you could have objective criteria, and you could have you could play duplicate bridge, as it were, have the same people, have the same objective criteria, run the system, run the candidate through one panel, and see whether they think the objective criteria are met in that instance, and then run the same person, same criteria through a different panel, and you might get a different result. If you got a different result too often, you'd have to just worry. Okay, so what do I think the objective criteria are? In my view, the objective criteria, I think, are actually relatively straightforward. The person has to be, he or she has to be smart. They have to be intellectually up to the job. And that's really important. For me, that is the very first criteria. If they're not smart enough, however good-natured they are, they're not good enough for the job. And the higher the job is in terms of judicial appointments, in my view, the more important that is. Secondly, they must have judgment. They must have judgment. Judgment in the sense of considered good judgment, by which I mean not just, there's a lot of smart people who can still make silly decisions. And you want somebody who is going to be able to use their hopefully considerable intellect in actually weighing and appreciating the facts of the case and the application of the law to the facts, whether it's a contextual text, a constitutional text or not, in a way which is indeed measured and judgmental in that sense. Third criteria for me is that I want the person who is writing the judgments to be able to write clear analytical judgments. I have a strong belief in the fact that judgments should be able to be read by any reasonably intelligent person, whether a lawyer or not. I understand there's going to be some legal technicalities, inevitably so, but nonetheless, I have a strong belief that legal thought and legal argumentation should be able to be presented in a way which is clear and analytical. And analytical I keep coming back to because it seems to me that the measure of all good judgments that I've read is that they have a strong analytical component. And a strong analytical component whereby the reader is taken through the story which constitutes the case in a way which seems natural and without problem. The fourth thing is that I want my judges, and this is the criteria for objectivity as well, an objective criteria, I want them to be honest and transparent. And I don't mean honest in the sense of non-corrupt. Of course we want them to be non-corrupt. I mean honest intellectually. I want the arguments on the table. If there is something driving a judgment in a particular case, If there's a normative argument, if there's a textual argument driving the particular reasoning of the judge, I would like that on the table so that it's out there to be evaluated. Judicial accountability is as important as political or administrative accountability, and transparency in the sense that I've just said, the honesty in terms of the principles or policies which are driving the judgment, seems to me, at any rate, a condition precedent in order to have a good judge. So those are my main criteria. I can fully accept that people may well differ as to whether those criteria are met or not in relation to a particular individual.
Well, just to quickly follow up on that, as in, do you think that judges themselves are the best judges of whether these criteria are met for these candidates? Because Pratap Bhanu Mehta, who's written in this volume, says that choosing judges is too important a matter to be left only to judges. We have this view that we can't trust anybody apart from the judges. So do you think these criteria can be assessed by politicians?
I think these criteria, my own view, and I realize that this is delicate terrain, particularly in present circumstances, my own view is that the best form of an appointment panel is indeed a mixed panel. Now, that may well be subject then to political circumstance and political contingency of the particular country. But as a starting point, I think a panel in which there are some judicial appointees, but also some people who are of sufficient intellectual merit and quality and trustworthiness, etc., etc., having them on the panel as well, I think is a good idea. So, without not trying to duck your question at all, indeed answering it directly, my view would be that I don't believe that judges have a monopoly in determining the criteria that I put on the table a moment ago.
Right. And Madhvi Diwan is here, and she's written a wonderful essay on the role of civil society in appointment of judges. And I was wondering, Justice Chelameswar, do you think that, as in one, do you agree with what Professor Craig said, as in terms of the need for non-judicial, by that I don't necessarily mean governmental inputs, but inputs from civil society, as in into determining who should be a judge, number one, if we were to architect a system. And given that the ultimate rationale for seeking that is essentially diversity on the bench, there is a criticism in India, as it was in the UK, that this is an old boys club and you only get a certain kind of man who gets appointed to the Supreme Court. So do you think that if we were to have greater civil society appointments, we might someday see a woman Chief Justice of India?
Last part of the question I didn't get repeated.
If there is greater inputs from civil society outside the judicial fraternity, do you think it might be possible in the near future to get a woman Chief Justice of India?
Well, I don't want to speculate on that.
I have no names in mind.
No, I understand, but I don't want to speculate on that. What is going to... See, the participation of the civil society necessarily need not lead to a particular result. Question is whether the participation of the civil society is a welcome feature or not. My views are already there on record. The AJSC matter. So.
That's right. So just as in to press, as in both of you a little further on this issue of diversity, Baroness Hale, if I'm not mistaken, is the first woman president of the Supreme Court. And is this... how much do you think this is a consequence of a changed system? I think that would sort of shed some light as to where we might be heading in India.
So if I understand you, what you're saying is, would Baroness Hale be president of the Supreme Court if we were under the pre-2005 system? I don't know. Very difficult to know that. I think actually in this particular instance she would have been. She was vice president beforehand. She was well respected. She writes considered judgments. She had support amongst other people within the Supreme Court. So, and actually, I also think that there was a strong, well, I think a reasonably strong feeling that that making Baroness Hale president would be a good thing precisely because of the gender imbalance which pertains within the UK judiciary. So having, in some senses, the most senior judge or most senior judge within the Supreme Court being a woman and also a woman with an academic background was felt to send the right message at the right time about attempts to improve gender equality in the UK.
That's right. And I think that's useful because at the end of the day, my personal view in the matter is, of course, that appointment of judges is a political process. As in there are elements of judicial involvement, but at the end of the day, someone must be politically accountable. And I'm just going to read a couple of paragraphs from what I think is a really insightful essay by Pratap Bhanu Mehta in the volume, and then I'll come to my question. He writes, "In this essay, I offer some skeptical reflections on the politics surrounding the establishment of the NJAC. The debate over judicial appointments is a political debate all the way down. It is a political debate in a very specific sense that I explain below. The dispute is political, not in the sense that it involves party or ideological politics, but it is political in the sense that the matter cannot be easily settled either by recourse to constitutional text, philosophical principle, or legitimacy of a process. What it requires is a good faith negotiation, a drawing up of a new institutional contract that is an exercise of all things considered good judgment." I think essentially the point that he's making in this essay is that there is currently a waning of trust between organs of government. And when there is a waning of trust, and this is not something that is true of at this point of time alone, there have been instances in the past where this has happened. When there is a waning of trust, then systems break down. Now, if we were to look into the future, Justice Chelameswar, and not look at the role as in the how to try and improve relations between the government and the judiciary, but what is it that you think are some critical reforms that the Supreme Court needs to institutionalize, not as a matter of law, but as a matter of continuing to remain the sentinel on the qui-vive as it describes itself? What are the critical reforms that you think the Supreme Court needs to undergo if it is going to remain credible in the public eye and retain public trust?
Actually, this is a topic perhaps on which it's possible to conduct a full-scale seminar. To answer this question, in my view, we must first understand what exactly is the problem. I can briefly indicate today. It's only from the point of view of the judiciary. I'm not talking about the executive part of it. That part, I'll leave it there. Even if the judiciary were to make assessments, what are the criteria on which this assessment is being made? Just remember, the Supreme Court today, the sanction strength is 31. The moment you create the Supreme Court with 31 judges, the highest court in this country, with all its aura and the authority and the jurisdiction it has, the first thing that happens in this country is every state believes it's entitled for a seat in the Supreme Court. That's the first thing. That's a problem which is already created because you have created a Supreme Court of 31 judges. When in the first court, this problem was not there. At least no state could say, look here, we want a seat in the Supreme Court. Now, more or less, now it's become an unwritten norm that statewide representation is to be given. Second, unfortunately, for the last, now it is almost 35 years, this policy of the transfer of the Chief Justices was adopted by the Government of India. Now, one thing I must say, whatever the merits and demerits, that's a different matter which can be debated later. One thing it must be said is this: whatever be the political party which wielded power in this country for the last 40 years almost, 1985, if I remember right, this policy introduced. On this one issue, all the political parties were united. Nobody wanted to change the system. This transfer of the Chief Justices, repeatedly the Chief Justice conferences have made recommendations, please have a relook at it. No political party which held power in Delhi was willing to do this. Now, this problem, this aspect coupled with the second judge's case, which spoke about, which created this concept of collegium, and said Chief Justices have a legitimate expectation to be considered for elevation to the Supreme Court. Now, see this, after this, the transfer policy, we have certain high courts which have more than one Chief Justice as a representative serving in some other courts. At a given point of time, I won't like to, it's not my idea to find fault with any individual or institution or anything like that. I'm only taking a factual analysis. At one point of time, in the recent past, a particular high court in this country had 4 Chief Justices simultaneously in this country, in different high courts. And right now, I think there's another court which has more than, there's more than one high court which has more than one Chief Justice. Some high courts have 2, 3 representation. And each one of them, by virtue of the second judge's case, would be legitimately entitled to be considered as per the law declared by the Supreme Court. These are all problems. Unless we have a comprehensive look at it. And then, question is the seniority. Once again, the claims of seniority. Seniority, which seniority? Is it the seniority of the Chief Justice? Or is it the seniority as a peonage judge? What we call All India seniority is a term which we borrowed from central services, All India seniority. Which seniority? If it is All India seniority, the seniority of a particular individual who had been a Chief Justice for a couple of years, would all that experience, is it worthless for consideration? I don't know. These are all matters to be debated, and so norms are required to be fixed. Maybe it's a matter to be considered by the court, by the government, maybe by the parliament, by all the concerned, by the nation as such. Unless these things are fixed, these controversies will continue, these problems will continue.
So, 2 thoughts immediately come to mind. First is, given your personal experience of being part of this policy, as in having followed this policy, you were yourself a Chief Justice in Guwahati, you were also a Chief Justice in Kerala. Do you think that there is any reason to think that the pre-Shiv Shankar days, where this policy was not there, would in any sense be better? Because there were arguments as to why this was created. You don't want your local politics to ensure that it clouds the Chief Justice's mind in any way, so it's better to get an outsider. You were an outsider in Guwahati for 3 years, in Kerala for about a year and a little bit more. Do you think that there was any benefit to having an outsider in a new jurisdiction for a short period of time?
From the point of view of the incumbent, there would be benefits. When I went to Guwahati or Kerala, I was an outsider. I had neither friends nor enemies, enemies in the limited sense, for lack of a better expression. The assessment of my work depended purely on the quality of my work. If I stayed back in Andhra Pradesh, every decision I rendered would have been looked at having regard to my background, my past contacts, my own, background, everything. Now, insofar as Kerala and Goa is concerned, it's wholly irrelevant. In that sense, from the point of view of the incumbent, it's an advantage. But the problem is this. There are two things. First of all, this whole policy is designed on the belief that a local chief justice belonging to the same state is likely to be influenced by the local factors. Are we sure that the chief justice coming from outside are not being influenced by the local factors? It all depends on who are his colleagues and what is his interaction with the colleagues, what is his understanding of the local factors. But all these things still work to some extent. To what extent? And second thing is, I remember when this policy was introduced, the then law minister made a thunderous speech saying that chief justices were building up empires. But I don't think the transfer policy made any difference. The empire still continued thereafter. The transfer policy didn't make any difference to that. And I don't know if that's the problem. The chief justices are building empires. Why don't we have transferred chief ministers? I don't think any chief justice would have any greater dangerous power than a chief minister, I suppose. If the damage to the society and the system is to be minimized or reduced or eliminated, why not we have transferred chief ministers? I mean, I think the whole perspective is a questionable perspective to my mind. But unfortunately, nobody is willing to debate it and look at it. And coming to the problems of this transfer policy. When an individual is transferred from one high court to another high court as a chief justice, just as you were mentioning, Arghya, that the average tenure of a chief justice of India in the last 10 years is about 11 months. The average tenure of a chief justice of a high court in this country is less than 1 year. Men like me are exceptions, forget about it, me and Patnaik. Is 1 year. And when I was sent from, I'll take my own case. When I was sent from Andhra Pradesh to Guwahati, it was a court with 7 benches, 7 different states, innumerable ethnic groups, 7 registries, 7 different set of rules, and every possible variation. How long would it take for anybody to get acquainted with this? It would certainly take some time. It's a different matter. I stayed back for 3 years and therefore I could broadly understand what is going on. If I were to stay there only for 10 months or 11 months or 1 year, I don't think I would have really had any grip of the problem there. This is what happens to any chief justice. By the time the chief justice understands what are the local conditions, what are the problems, and starts to deal with it, either he is already elevated to the Supreme Court or retired, if not transferred. Occasionally it happens, he is transferred to some other high court. I don't really believe that it solved any great problem, this policy. And there's a lot to be looked at it in this. If you were really talking about improving the system and the quality of the Supreme Court.
That's right. I think it requires a much fuller discussion. Paul, have we lost you entirely on this? So, then 2 thoughts, and given that you come from a different constitutional culture. One is seniority. Does it resonate that this, because some of what we've got in terms of seniority is essentially a throwback to the colonial era, where there is a certain degree of progress that is synonymous with age. And seniority is most certainly some kind of grunt norm in the Indian legal profession. I remember the first day that I went to the Supreme Court, even as an advocate, if you were sitting on a chair in the Supreme Court, you had to get up if there was someone more senior who came in, even if it was the 4th row and the 2nd seat at the back. And it struck me as a bit surprising as to how pervasive seniority was. And so the one thing is on seniority. And do you think, coming from a different constitutional culture, that it should have, and I'm being provocative, any relevance for appointment of judges to the Supreme Court from high courts? And second, which is related to that, a Supreme Court of 31 judges, is this something that you can wrap your head around, given the fact that it is the highest appellate court in the country that's supposed to decide, according to the Constitution, constitutional issues of fundamental significance?
I missed the latter part of the question, or the second limb of the question.
Do you think 31 judges is an appropriate number, or would you think if you were constructing a Supreme Court, it would be a more manageable number, given the fact that you expect that not all cases in the country would come before it?
Okay. So being provocative in relation to, or not ducking the provocative questions that you have asked, my own view is that presumptively I don't think seniority should really make a difference. I mean, once you set a certain benchmark, and I'm not trying to then reel back from the point I just conceded or just made. What I mean is that in the UK, the very fact in the UK that judges, the very great majority of them are going to be appointed from the bar, means that, and that therefore they would have to be a QC, so therefore at least 10 years standing, etc., means that you're going to have a minimum age threshold built into the system in that way. Once that has been, once you've surmounted that hurdle, then in terms of appointments to the High Court, so we've got High Court, Court of Appeal, Supreme Court, my own view is that once you've surmounted that hurdle, in terms of appointments to the High Court, I don't believe that seniority should matter in the sense of whether you practice as a QC, whether you practice as a barrister post-appointment for 10 years or 15 years or 18 years, I don't think should matter at all. So that's my view. When you are then considering elevation from High Court to Court of Appeal to Supreme Court, I think that I don't think seniority qua seniority should be determinative. What I do think is that it is a relevant consideration how much judicial judging experience you have had in the High Court before you go to the Court of Appeal, in the Court of Appeal before you go to the Supreme Court. And again, I can't put numbers of years on it, but it does seem to me it's not seniority, it is the fact that you have had some experience at the High Court trial level before you go to the Court of Appeal, and then you'd have had some experience at the Court of Appeal level before you go to the Supreme Court. But again, in order to answer your question as directly as possible, in my view, once you've got across a minimum amount of experience, or the experience that you need to have under your belt in order to make the transition to the next stage, the fact that somebody else has twice as much experience as you, if you're better, you should go up to the next level and not the next person. On the second part of the question, 31 judges, the nearest analogy I have with that issue is in relation to the Court of Justice of the European Union, where there's one judge from each state, and that means that there's 28 judges. And there has certainly been concerns about the shift from a judicial body to a deliberative body. And I think that numbers matter in that respect. Now, the way in which the Court of Justice of the European Union's got over that is that it has rules for what counts as basically a plenary court or a full court. Most cases are heard in divisions of 5, sometimes 13, sometimes 15. But I think that, in my view, anything above 15 makes it difficult to engage in something which is meaningful adjudication rather than moving across a boundary which is real between deliberative adjudication on the one hand and something which is more like a deliberative assembly on the other.
So, Justice K.T. Thomas suggests something similar in this volume, where he says that for any basic structure challenge, given the fact that there might be quite a few, a minimum of 13 judges should be sitting, because it's the same as Keshwanand. And second, that there should be a permanent constitution bench that should be sitting in the Supreme Court, given the fact that it was set up in order to determine questions of constitutional law. And it should not be a bench of 2 or 3 judges, as is the case currently, because we usually sit in division benches of 2 or 3. Do you think the time has come for a permanent constitution bench of the Supreme Court, whoever may be sitting on that bench, and for a large bench of an authoritative number to hear questions of basic structure? Because I think ultimately the question is of legitimacy and authority that it carries, and it shouldn't become someone taking a chance at the Supreme Court, because essentially it involves trying to persuade the senior judge or 2 judges at most.
It is certainly an idea which I would welcome. But the problem is this. It first requires a clear relook at the jurisdiction of this court. I am sure you must have noticed in my court, occasionally I comment. I don't think Dr. Ambedkar and B.N. Rao and Saraladi would ever have dreamt that the Supreme Court would one day hear bail applications. The manner in which the jurisdiction of this court expanded or invoked really added to the problem. Now, if this court were only to decide constitutional issues, really this court didn't perhaps require 31 judges. Now, of course, I might be misunderstood today saying that on the verge of his retirement, he's trying to retrench people from the Supreme Court. That's not my idea. I'm on a theoretical problem. But point is, then the minute you have a court with 31 judges and division benches, 12 or 13 division benches with 2 or 3 judges, as the case may be, each one of the benches is the Supreme Court, and each one of them, the benches, have the legal authority to determine whatever question that arises, apart from the judicial, the norms of judicial discipline and all those things apart. If it is to be structured, it is to be structured by some appropriate process. Is it a law? Is it amenable to the lawmaking of the parliament, the structuring of the jurisdiction? And these are all questions which require. But certainly something like that is required. Otherwise, we have a lot of this. How many cases are pending before how many references are pending in the last 10 years in the court, in the background of conflicting opinions of this? All this happens because of this division benches problem. And each one of these benches would have spent sufficient time on those cases. It is simply duplication of the work that could be avoided.
But one could argue that this is a problem of the Supreme Court's own making, given its taking up of 136 matters. Now, I agree that it could be because the quality of justice at the level of the High Court is perhaps not up to the mark at all points of time. But do you think it requires a conscious effort on the part of the Supreme Court to not give special leave to appeal in as many cases as it does?
See, Arghya, to say that the quality of the High Courts is not up to the mark, well, anyway, I don't want to make any comment on that.
Well, I would say that, but the stats speak for themselves the way the Supreme Court admits cases.
That's right. But the point is this. If there were to be another appellate court above the Supreme Court, I am sure half of our judgments would be reversed. Not because we are writing wrong judgments. Ultimately, law is a matter of opinion to a large extent. But that's not the point. This country functioned without a Supreme Court for almost 100 years, where the High Courts were almost the last courts. Very few matters went to the Privy Council. High Courts handled the problem. And those days, the High Courts, I suppose, produced some of those outstanding judges And some of those great judgments were rendered by those High Court those days. It's the basis on which the Supreme Court built up its jurisprudence subsequently. Now, if the quality of the High Courts is not up to the mark, we must devise ways and means to improve the quality of the High Courts and strengthen the High Courts. Adding numbers to the Supreme Court, I don't think is going to. Ultimately, where do you get these judges to the Supreme Court from? From the same stock? That's right. And once again, on the same principle of seniority or regional representation, that representation, this representation. How is it going to solve the problem?
Well, I think that's some of these questions are discussed in great detail in the book. So, if you're interested in knowing more, then please do buy the book. I think we have time for about 10 minutes of questions. Now, just a couple of ground rules for these questions is that one, given the fact that Justice Chelameswar is a sitting judge, no questions on any of his judgments. If you have a question on his judgment, please direct it to Professor Craig. And number two, as in the answering of the questions is at the discretion of the panelists. So there is no legitimate expectation to an answer. Having said that, we can take two or three questions. We'll take one from a student here and then Manish at the back. Yeah. Could we have a mic to him, please?
A very good evening to the respected panelists. I'm Jayakrishnan and I'm a student of Amity Law School, Noida. My question is to Justice Chelameswar. Your Lordship, there have been a lot of appointment problems in the Supreme Court. It's not only the Supreme Court but in the lower courts as well, like in the high courts where there are a huge number of vacancies. And plus there's been a lot of things regarding the transparency in the collegium system. That even though there were problems, there were statements that the collegium published its resolutions on public domain. So do you think that this can establish a more transparent system?
Okay, thank you. Manish?
So, my name is Manish Chamber. Two quick questions. Sir, do you think if the, Justice Chelameswar, do you think if the retirement age of High Court judges is also raised to that of the Supreme Court judges, many of the High Court judges would may actually not prefer coming to the Supreme Court? And second, 2 days ago you said you have decided not to accept any post-retirement job. Do you think we should have a law, or maybe time has come for such a law, so that our High Court judges and Supreme Court judges are deprived of any post-retirement jobs? Thank you.
My personal opinion is raising of the age of superannuation of the High Court judges will not solve the problem. My own understanding. I'll give you the reasons why I believe so. Ultimately, so long as elevation to the Supreme Court is looked at as some kind of a recognition or promotion, because your whole system, Indian system, works on this hierarchy, seniority, promotion, higher levels. So long as that remains, just giving 3 more years to the High Court judges, I don't think is going to solve the problem. The concern, and more particularly, in the last 30 years after of the experiment of these transfers and so, it's power. Somebody who gets to the Supreme Court wields that power. People would, there's human nature. If all of us who have been students of law, who are taught in the law school, in jurisprudence, the ultimate value which a human being cherishes is power. So long as a seat in the Supreme Court continues to be a source of power, this is not going to solve the problem. What is the second question you asked about? Well, it's a huge matter to be debated. I announce my personal decision. I don't want to palm it off on others. It's a matter for the nation to debate and decide.
And I think on that point, the first point that you raised, there was a bill, which I think Mr. Khurshid is here, as in the 114th Constitution Amendment Bill, which was moved, in order to equalize the ages. And I think there was a proposal to link that equalization with a bar on post-retirement employment as well. But maybe that's why it fell through. There's a question here and one here. Then we'll...
Hi, I'm Vikasha. I'm with the Quit journalist, also former lawyer. I have one question for each of the panelists. For Justice Chelameswar, you mentioned in the letter, you and the other judges, you and the other 4 judges, the other 3 judges in your letter had mentioned the R.P. Luthra case, and specifically in the context of that, why there needed to be a new, apart from impeachment, other forms of...
I'm not answering these questions.
Sure.
Professor
Sure. Professor Craig, one of the issues which has been raised potentially is, and you talked about, for instance, judges having to be very smart and having a great amount of judgment. In the UK, for instance, the TCC, the Technology and Commercial Court, used to have construction, used to have Vivian Ramsey, who was the leading authority on it at a trial, it's essentially a court of first instance. How can we work at ensuring in India that even the judges at the courts of first instance are of such a high quality? And he never even went to the High Court. He's retired from the TCC itself. What are the factors which allow a judge to actually attain that kind of expertise and yet be only someone at the court of first instance, or should that not matter?
Maybe we'll collect one more and then take it together. There's just one question here and we'll stop.
I'm Damayanti. I'm from India Today magazine. I have 2 questions for the 2 of you. Professor Craig, the first thing is that you mentioned the objective criteria. But they were terrific, actually. But, I mean, who is to decide who is smart enough intellectually? Isn't that essentially subjective? That's one. And, sir, to you, I mean, the nation watched during the press conference, and there was tremendous debate, and it was a lot of interpretation, and it was called unprecedented and everything. No, sir, to you. So I wanted to ask you, what are the 3 things you think the Supreme Court must do now to change the public perception and trust?
Ma'am, we are only dealing with the judicial appointments. The book is about the judicial appointment. Let's not
I know, sir.
Let's not go into these things. I don't want to make it an everyday affair. Please, please.
Sir, at least on appointment of judges?
Sorry?
Maybe something on the appointment of judges that the Supreme Court must change.
I mentioned already, said we need more transparent criteria for this. I already said it.
And I think that one of the, as in if I may just sort of butt in here, one of the things that despite the fact that we all know that the collegium is in the state that it is, one of the most creditable things that this collegium has done is that it puts out transparently the people who were considered and those who were taken. So I think this is something that this collegium has done. So it's essentially walking the talk in some sense.
In fact, I may inform, one of the steps taken in the recent past is that the collegium has decided to have a session of interaction with the candidates whose names are being considered, which has not been done so far in the last 70 years in this country, and not for the last 25 years ever since the collegium system came into existence. The last 1 month, and we considered the names from 3-4 different high courts, we requested the candidates to come for an interaction with the members of the collegium. We are trying to make it a little more transparent. It may not be the ultimate step, but it's certainly one more step towards transparency.
Yeah, there were 2 questions. Just to respond briefly to both. In terms of your question about the Technology and Construction Court, I don't have any particular information about why ad hominem, why that particular person did not go forward or beyond that. But answering your question in more general terms, I think we can identify certain criteria or conditions as to why you're more likely to get good people even at the High Court level. Okay? And I think one of those conditions is there has to be a sufficient incentive. It's a necessary, not sufficient condition. But one of the conditions is there has to be a sufficient incentive for the person to move from a lucrative practice at the bar to a position on the court. If the pay differentials become too large, then other things being equal, at the very least, you're going to reduce the likelihood that someone's going to move from private practice to public service. And just to take a point, a particular point about this, in the UK at present, the pension rules for judges on the courts have changed in a rather technical way, which I won't go into now. But it is manifestly clear that those changes have had a fairly dramatic negative effect on the attractiveness of moving from practice to the courts. So I think one answer to your question is you don't get anything on the cheap, and if you want good judges, then you're going to have to pay them, particularly given the opportunity cost in terms of what they can earn if they don't go on the bench. So that's the answer to the question. The answer to the other question, thank you for that. I mean, of course, there can be differences of view about whether someone's smart, but I don't think it is a matter of pure subjectivity. So how do we determine it? Well, partly we determine it in the same way as we determine it in any other context. We look at their CV, we look at their educational qualifications, we look at their degrees, we look at the kinds of results they got in their degree, and then certainly in the UK system, by the time anyone is going to be considered for a judicial appointment, you have a lot of information out there about the quality of their advocacy, which you can draw on. And I think it's not that difficult to determine whether someone's a perfectly reasonable but journeyman advocate, as it were, using that in a non-gender specific sense, but just perfectly reasonable advocate, does a good job, but doesn't have any particular great insight or intellectual power, and to distinguish between, you know, the ordinary Volkswagen going along the road and the high-speed Mercedes passing on the outer lane.
So I think that's a strong sentiment that we increase salaries and move to a more transparent application process. We have two last very quick questions. There's one here and one here. I'm sorry, we just can't take any more. We just get two here and then we'll just wrap up.
My question is more of a general nature and anybody can address that. At the very outset, it was stated that Justice Chelameswar said that one constant that is expected in a judge, that he has to be not a partisan judge. And other things can be as per context, you know. Now, I come from the field of writing. I'm a journalist, and I have read reports of the law commissions which have said that judges are as human as anyone else, despite they being very erudite or cerebral, you know, than common people. And we have seen a number of instances in our country, especially, where judges, instead of following the law, seem to be at lower tiers of judiciary, at least, following the noises on the ground, you know. For instance, in our country,
so if you could keep it as
for instance, in our country, bail is not a right in many cases, you know. Jail is the thing to do. So this is gross miscarriage of justice. And how is it that the highest court of the land has allowed it to happen? How have the high courts allowed it to happen that have administrative jurisdiction over lower judiciary?
We'll take one there.
Yeah, hi, my name is Rajat, and though I'm not a lawyer, I did my master thesis on judicial appointments. And I just had a question, since the NJAC has been now struck down and the memorandum of procedure for appointing judges is under consideration. And one of the concerns with the NJAC was the fact that the composition of the council, the commission was under question. Is there any way that another form of NJAC can be recommended that might then be passed?
And since we don't have a woman on the panel, we'll finish with a question from the woman there who's had her hand up for a while.
Thank you. Good evening, I am Charu Mathur. I am an advocate at Supreme Court. I have a question like, the idea of judiciary is to have independent judges. But once they are judges, they all get into a normal rat race like all the services. So don't you think it is a better idea to have exam or a commission like ICS used to have? And second part, Lordship, pardon me if I offend somebody, the interviews which were done for the collegium, for the selection of the judges by the collegium, I think they were little extra constitutional.
Please avoid the word interview. We very calculatedly avoided the word interview. We thought it would be a little offensive.
Yeah.
We said we requested them for an interaction, that's all.
Lordship, but many of them in the press, they reported as interview, and as a lawyer, I felt very offended that why these people are going for interview. I have a certain pride as a lawyer. So many magazines, many news reports, they reported as interview. And even interaction, I don't think, Lordship, it is the part of any of the judgments.
Okay, thank you. Is there, the first one, do you want to take anything of these questions? Is there anything that...
Well, I didn't think I'm competent to answer anything about the second or the third question. Just on the first question, I mean, the first question is an endemic problem, an endemic issue in any legal system. And I don't think that there's a single answer to it, because I think that the kind of problem or malaise to which you refer can only be either prevented or alleviated if it occurs by a range of considerations. One is a proper sense of what adjudication entails. And that's, I can't produce a magic wand, which, if I could produce a magic wand, then I'd be a very rich person selling the magic wands in different legal systems to ensure that people properly understood the public duty that they were discharging when undertaking adjudication. But it does seem to me, although it sounds rather simplistic, that is the very core of the answer if one's going to give a brief core answer to your question. Judges have to be mindful of the public duty that they are discharging, and that public duty has to be discharged in the light of the relevant positive law and normative principles which underlie that positive law, and it should not be swayed by populist feeling, whichever way that populist feeling is going.
And I think if you do want an answer to the second question, it's answered in several essays in the book. So this is my second plug and the last plug to this evening for the book. Thank you very much, ladies and gentlemen. Unfortunately, we have to bring this to a close. I'd like to quickly invite Sugato Ghosh from the Oxford University Press to say a few words in closing.
Thank you, Justice Chelameswar and Professor Paul Craig, for giving us your valuable time and for building up that fantastic discussion on a topic of very contemporary importance. As you are aware, Oxford University Press is a department of the University of Oxford. It furthers the university's objective of excellence in research, scholarship, and education by publishing worldwide. And we are delighted here to be a part of this evening, releasing the most important book that we have been talking about. I would like to express our sincere thanks to both the editors, Dr. Arghya Sengupta and Ritvika Sharma, for their cooperation throughout the entire publication process. It was a pleasure for us at the press associating with them. The book is a significant contribution to our list of global legal publication. Last but not the least, I would take this opportunity to thank distinguished guests present here today for taking time out of their busy schedule on the first day of the week. Thank you very much. Thank you once again and have a wonderful evening ahead.